A woman walks into her local bank branch 3 weeks after burying her husband of 41 years. She hands the teller a death certificate and expects the joint account they'd shared since 1985 to simply become hers. Instead, she's told to sit down because depending on how that account was titled and depending on how much money is actually sitting in it, she could be about to lose access to part of it or wait months to see the rest. By the end of this, you'll know exactly what to check on your own joint account this week in about 5 minutes. And stick around for Rule 3 because it's the one that decides whether your money transfers to you in a single afternoon or gets tangled up with the rest of the estate for months. And almost no married couple checks it until it's too late. I cover the real financial rules that affect seniors directly every single week. The rules that changed, the protections you already qualify for, and the steps that actually make a difference. This is exactly that kind of video. If that's what you're after, hit subscribe and turn on notifications now because I put these out weekly and you don't want to miss the next one. Here's the part that should make you angry, a little. There are 3 rules working in the background right now that decide what happens to your joint account the day one of you passes away. Most couples have never heard of any of them, not because the information is hidden, because none of these rules come with a letter from the bank explaining what changed. Nobody is required to flag it for you. You're just expected to already know. Rule 1, how much of that money is actually insured once the account becomes yours alone. Here's what most people get wrong. They assume that whatever sits in a joint account is fully protected by the FDIC, no matter how large it gets. That was never quite true. And in 2024, the FDIC changed the math on it. Under the current rule, coverage on accounts with named beneficiaries, payable on death accounts, is calculated at $250,000 per beneficiary, up to 5 beneficiaries, for a maximum of $1,250,000 per bank, per owner. Here's why that matters the moment you're widowed. While the account was jointly held, each co-owner's share was insured separately, often adding up to $500,000 or more in total protection. The instant that account transfers into your name alone, it typically stops being a 2-person account and becomes a single-owner account. That combined protection disappears with it. Add beneficiaries afterward, and you get recalculated under the newer formula. Skip that step, and a single-owner account with no beneficiaries named is only insured up to a flat $250,000, no matter how large the balance grows. This is where it quietly goes wrong for people. Widows and widowers consolidate, closing a checking account here, moving a CD there, and don't realize they've pushed the balance past what's actually insured. Life insurance proceeds do the same thing overnight. None of this happens because anyone made a mistake. It happens because the account changed categories the day it changed hands, and no one at the counter is obligated to mention it. It also isn't just about one account at one bank. Each institution calculates coverage separately, which is good for spreading risk. But a widow who consolidates smaller accounts from several banks into one, thinking she's simplifying her life, can accidentally walk a balance that was fully insured across those banks into a single account that's only partially covered. Here's the test. If your total balance at one bank could reasonably approach or cross $250,000, that's your cue for a direct conversation with your bank about titling. And beneficiaries, don't assume it's handled. Ask. It's a 5-minute conversation. It's the difference between every dollar being protected and a portion of it sitting outside FDIC coverage without you ever finding out. And if you're not sure how close you are to that line, ask the bank to run the numbers with you directly. They have calculators built for exactly this. They just don't offer to use them unless you ask. Rule 2. How the account is treated for estate tax purposes, even if you never expected estate tax to touch you at all. Under Section 2040 of the Internal Revenue Code, a joint bank account between spouses is automatically treated as owned 50-50 for estate purposes. no matter who actually deposited the money over the years. So when your spouse passes, half the account's value is technically counted as part of their estate, even though the funds pass to you outright through right of survivorship. Now, for most families, in practice, this changes nothing. There's an unlimited marital deduction that shields anything passing to a surviving spouse who's a U.S. citizen from federal estate tax entirely. In 2026, the federal estate tax exemption sits at $13.99 million per person. So the overwhelming majority of couples will never owe a dollar of federal estate tax, regardless of how the account splits on paper. But here's what doesn't get said enough. This rule matters a lot more if your spouse wasn't a U.S. citizen. The unlimited marital deduction doesn't automatically apply there. A different mechanism, a qualified domestic trust, may need to be in place instead. And without it, that 50% could be exposed to estate tax even at a fairly modest balance. If that's your situation, the standard advice you've heard about joint accounts doesn't fully apply to you. Talk to an estate attorney directly, and don't stop at the federal number. Close to 20 states plus Washington, D.C. run their own separate estate or inheritance tax, and several set the exemption far below the federal threshold, in some cases as low as $1 million. Massachusetts, Oregon, and Maryland come up often. If your household's total assets, not just this one account, land anywhere near that range, check your specific state's threshold before assuming the federal exemption is the only one that matters. It's worth understanding why that 50-50 assumption exists at all. The IRS doesn't know and generally doesn't ask who actually deposited the money over the decades. For estate purposes, the law simply presumes equal ownership. That's what makes the marital deduction so useful. It doesn't matter whose name earned the money, since the deduction covers the whole transfer regardless. But that same presumption is exactly what becomes a problem when the marital deduction doesn't apply, which is why the citizenship question isn't a small technicality. So here's what I want you to do. The benefits, the discounts, the assistance programs most seniors qualify for but never actually use. I gathered them all in one spot, organized by state and by program, so you don't have to dig through confusing government websites for hours. It's quick, it's straightforward, and any senior can find exactly what fits their situation. No matter what state you're in, there's help out there you're probably leaving on the table. It's called the Senior Exemption Playbook, and it's sitting in the first pinned comment right under this video. Just tap it once, and you'll have everything you need. Now stay right here, because the last one is the most crucial rule. Rule 3, the titling exception a lot of couples don't realize applies to them. Most joint accounts between spouses carry right of survivorship, meaning the account passes automatically and entirely to you the moment your spouse dies. No probate involved. But if you live in a community property state, Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, or Wisconsin, your account may not be titled that way at all. In some of those states, an account is classified as community property instead of joint tenancy with right of survivorship. When that's how it's set up, only half the balance automatically belongs to you. The other half becomes part of your spouse's estate, distributed through the will, or through probate if there isn't one. This isn't automatic in every community property state. Plenty of accounts there still carry standard right of survivorship. It comes down to exactly how the paperwork was worded the day the account was opened, and you can't always tell just from your monthly statement. This is also where couples who moved states later in life get caught off guard. If you opened the account decades ago elsewhere with standard right of survivorship, then retired to Arizona or Nevada, the titling doesn't update itself just because you moved. But some banks repaper accounts when you open a new local branch relationship, and you can end up with community property titling without ever intending to change anything. So here's the test. Call your bank and ask them plainly, does this account carry right of survivorship, or is it titled as community property? Get the answer in writing if you can. That answer alone tells you whether you're walking out with full access the same day or waiting on probate for the other half. Confirm it. Don't assume it. That's the whole rule. Now, a handful of practical things that catch surviving spouses off guard, no matter which of the three rules applies to you. Your account isn't going to freeze the way people fear. Bring in a certified copy of the death certificate, not a photocopy, an actual certified copy from the funeral home or county vital records office, and the bank retitles the account into your name. You keep using it. Order at least 8 to 10 certified copies up front. You'll need them for Social Security, pensions, insurance, and the DMV too, not just the bank. The money already sitting in the account isn't new taxable income to you. You already had an ownership interest in it. So inheriting full ownership isn't a taxable event. What is reportable is any interest the account earns from the date of death forward, since that now belongs to you under your own Social Security number. Ask your bank whether any automatic payments, direct deposits, or linked accounts were set up under your spouse's name, Social Security number, or login. Pensions, annuities, certain bill payments sometimes need to be reestablished under your information. And this gets missed constantly, simply because nobody thinks to ask in the middle of everything else. It's especially common with automatic bill pay on utilities or insurance, where the account number stays the same, but the authorization behind it was tied to your spouse, and the payment can silently fail weeks later. It's also worth checking safe deposit box access separately from the account itself. Banks sometimes treat that differently, and if your spouse's name was the only one on the signature card, you may need a court order just to open it, even while the checking account transfers to you the same afternoon. And here's one that surprises people. If a joint account wasn't set up with right of survivorship, structured instead as tenancy in common, which is uncommon but happens, your spouse's share doesn't pass to you automatically. It becomes part of the estate. You may need an executor or probate to access it, even though your name was on the account the whole time. Once things settle, take 15 minutes and add a payable on death beneficiary to the account. If that joint account used to help the two of you avoid probate together, it stops doing that job the second you become the sole owner. A PO designation is usually a free form at your bank. It means the account passes directly to whoever you name, no probate, whenever it's your turn. 15 minutes now can spare your kids months of court process later. One more scenario, and it's not about spouses at all. If your joint account was set up with an adult child to help manage your finances, the rules shift. The IRS may look more closely at who actually funded the account, and if that child withdraws money you funded entirely, those withdrawals could in some cases count as taxable gifts. The annual gift tax exclusion, $19,000 per giver in 2026, covers most everyday situations, larger sums, and it's worth a conversation with an accountant. If you're navigating this right now or getting your own accounts in order ahead of time, here's your list. Order several certified copies of the death certificate before you need them. Ask your bank directly whether your account carries right of survivorship or community property titling, and get it in writing. Check whether your total balance at any one bank, once consolidated, is fully covered under current FDIC rules. Add beneficiaries if it isn't. Update your will and your POD beneficiaries once the account is solely yours. And if you're in a community property state or your spouse wasn't a U.S. citizen, put a call to an estate attorney on that list, instead of assuming the standard rules apply to you. None of these three rules exist to make this harder on you during an already hard time, but the bank isn't sending a letter explaining any of it. And most couples don't think to ask until they're standing at the counter holding a death certificate. Knowing them now means one less thing to figure out on what's already one of the hardest days there is. It's not just paperwork, it's making sure the person who spent 40 years building a life with you doesn't leave a mess behind by accident. This is general information, not personalized advice for your specific account. Confirm the details with your bank directly or with a qualified estate attorney before you act on any of it. And go check your own titling this week. It takes 5 minutes.